In an exclusive interview with this newscast at the weekend, attorney-at-law Mayo Robertson made several disclosures concerning the actions of the Chief Elections Officer of GECOM, Keith Lowenfield. It was first inquired of the attorney as to whether the CEO had violated the order of stay by the Court of Appeal by submitting his report to the chairman, to which he responded.
But my opinion is that he did not violate either the letter or the spirit of the order. The stay order was meant to make sure that there was not a declaration of a winner during the period of the stay. There was nothing that said Mr. Lowenfield could not continue with his constitutional function.
While some attorneys and political activists, among other public figures, have been calling for a retraction of the CEO's report to the Commission, the attorney has asserted that there is no constitutional provision for such.
I'm not aware of any provision in that legislation that allows for the retraction of a report. Framers wanted there to be some degree of independent input between the poll box and the Commission. And that independent reporting falls squarely on the shoulders of the Chief Election Officer by our Constitution.
A day after the ruling by the Court of Appeal, the Chief Election Officer had submitted a report to the Elections Commission based on the order of the court, that is, valid votes only should be tabulated to form the winner of the elections. In that report submitted to the Commission, it reflected the APNU AFC as winning the election with 171,825 valid votes, while the PPPC garnered 166,343 valid votes, followed by the smaller parties. This report has had much resistance, to which the attorney had this to say.
The Constitution requires him to exercise his own deliberate judgment on what is valid and what is not valid. But it doesn't end with him. The court still has overriding authority, just not at this stage. Once he makes his declaration, once he makes his report rather based on valid votes, and a declaration of the election is made, then his judgment could be questioned in an election petition, and a court could very well overrule him.
The CEO, in a statement on Friday, has also made it clear that he executed his constitutional duty as a public officer. Meanwhile, on Thursday last, the Caribbean Court of Justice held its case management hearing, where it was discovered that neither the CEO nor the Elections Commission had legal representation. This newscast inquired of possible consequences for not appearing at the hearing. To this end, the attorney had this to say.
It's not uncommon at all for a party who is served with process to decide whether or not he or she is going to participate, if they can really add anything to the process.
Chairperson of GECOM, Justice Claudette Singh, retired, on Sunday tendered a letter to the Caribbean Court of Justice through her attorney, Kim Kite Thomas, notifying the honorable judges of the court that, and I quote, notifying the honorable judges of the court that, on further consideration, she does not wish to actively participate in the appeal and therefore does not wish to make any submissions. Reporting for HGP Nightly News, Wendell Badrie.